I have it. This I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're
That
also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm
that
not wasting any more time on it. We are done. All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez, Your Honor.
There you go. All right. So Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said.
Welcome back, everyone. Today, we're looking at another unusual sovereign citizen court hearing. This time, the man is in court over something many adults have struggled with: credit card debt. Instead of simply acknowledging his responsibility, like most people would, he takes a strange approach, claiming that credit cards aren't real and that the court has no authority over him because, according to him, he's a living man. Of course, the judge isn't having any of it. She keeps pulling him back to reality, but honestly, I don't think anything could break through the fantasy this man seems to live in. I still can't believe there are people out there who think saying I don't consent is some kind of valid legal defense. What do you think? Do people like this truly believe what
I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent all documents except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that.
they're saying, or are they just trying to dodge responsibility? Let's take a closer look. You can immediately tell this man refuses to take any accountability. Instead of addressing his unpaid credit card debt, he tries to flip the situation and claim the bank somehow owes him money. It's like running up a huge dinner bill, refusing to pay, and then blaming the chef because you didn't consent to eat. Either this man genuinely believes this nonsense, or he's just incredibly committed to the act. It almost feels like he's watched a few too many questionable YouTube videos and thinks he's discovered some secret loophole in the legal system. What's your take? Is this delusion, or is he trying to pull a fast one? Let's keep going and see how this unfolds. That wraps up the first hearing, and honestly, it was—
And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If that if my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Yeah, motion for summary disposition. Hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir?
It's tough to watch. Trying to reason with someone who's convinced they've found some magical legal argument is exhausting. It felt like he thought he was auditioning for a TV drama rather than appearing in a real courtroom. That said, I'm curious to see what happens next. What other legal theories will he come up with? Let's move on to the next hearing and see how far this story goes. To be fair, I think the judge handled the situation well. I've certainly seen worse behavior from sovereign citizens. Still, this man clearly lives in his own world, where laws somehow don't apply.
All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Gopal, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Why? Credit card debt is serious. It builds up fast and can become overwhelming. That's why people need to stop pretending to be lawyers and seek proper legal advice. If he had simply said, "I'm struggling right now. Is there a way to work out a payment plan?" things could have gone much smoother. Instead, he's standing there talking nonsense about how he's the creditor and the bank is the debtor. Newsflash, if you used the card, you owe the money. Unless he's hiding some secret legal trick no one's heard of, his argument isn't going to work. Honestly, I'm surprised he was ever approved for a credit card in the first place. He must have filled out that application with the same misplaced confidence he shows in court. A decent lawyer and just a little bit of common sense could have saved him all this trouble. But here we are, watching this unfold like a train wreck. So, what did you think of these hearings? I found them both frustrating and strangely educational. How do you think the judge handled it? Too lenient? Just right? Or should she have been tougher? Let me know your thoughts in the comments. And if you enjoy seeing how these sovereign citizen cases play out, make sure to like, subscribe, and turn on notifications. I post new content every day, so stay tuned for more courtroom drama. Thanks so much for watching, and I'll see you in the next one.